Okay, I think we might make a start as we're in for a bit of a treat in terms of the discussion and conversation and presentation that we're going to have today. Good afternoon, good evening, good morning, everyone. My name is Radha Govil. I'm the Deputy Director at the Peter McMullin Centre on Statelessness, and welcome to this Asia in Focus seminar. I would like to start by acknowledging the traditional owners, the Wurundjeri Woiwurrung, whose unceded lands this seminar is being hosted upon. I would also like to pay my respects to elders past and present, and in doing so, I would also like to acknowledge the all too frequent treatment as second-class citizens of traditional owners of our lands, and the importance of remembering and acting on this as we pursue our work to further the enjoyment of the right to nationality for all. Today's Asia in Focus seminar focuses on the ongoing debate and battle in Malaysia between a very active network of civil society actors and the government to ensure positive law reforms to prevent statelessness and to prevent regressive reforms which could see the unmaking of safeguards to prevent statelessness, particularly amongst children. I'm therefore delighted to introduce to you today today's speakers. Firstly, we have Suri Kempe, who is an independent activist and consultant who has been advocating for gender equality and justice for over a decade, and is a co-conspirator of many different social justice projects and law reform efforts in the country and globally. She has done this while working for the United Nations Development Programme and Malaysia's Ministry of Women, Family and Community Development. And she's also taken on various leadership roles within civil society with organisations such as Sisters in Islam, Musawa, Family Frontiers, Arrow and Queer Lapis. In addition, we have Maalini Ramalo, who is the Director of Social Protection of Development of Human Resources in Rural Area, DHRRA, Malaysia. She currently leads the Statelessness Unit at DHRRA, supported by a team that focuses on evidence-based advocacy and provides direct services to stateless persons with strong links to Malaysia. Alongside DHRRA, she has successfully advocated for policy change, specifically to education access and standard operating procedures to benefit stateless persons with Malaysian parents. Both Suri and Maalini's organisations work under the banner of the Malaysian Citizenship Rights Alliance, a coalition of concerned citizens, activists, and 20 organisations dedicated to upholding the rights and dignity of all stateless persons, those impacted by discriminatory citizenship laws, and those potentially impacted by the proposed regressive amendments to the Federal Constitution of Malaysia. Suri and Maalini have prepared a PowerPoint presentation that they're going to deliver together, and we think that will take around 30 minutes, leaving us with ample time to have a robust conversation and for you to ask any additional questions you might have or raise examples from your own spheres of experience in relation to some of the issues that they're going to raise through the course of their presentation. Could I just ask before they start if everyone during their presentation could keep their microphones on mute, and when we come to the Q&A part of the conversation, if you could just use the time-honoured tradition of raising your virtual hand. I'll take a list of speakers and we'll do them in sort of batches of questions. So without further ado, I'll pass over to Suri and Maalini. Thank you.
Thank you so much, Radha. Can everybody see my presentation? Yes? Okay, wonderful. Well, thank you, everyone. It is lovely to be here, and thank you so much for hosting us. What this really is a story about coming together, right? How two issues that were typically addressed separately converged, and how this resulted in more advocates coming together in solidarity. And this is in part why Maalini and myself decided to tag team this presentation. It's not my story alone to tell, and neither is it solely hers. This is a story that we felt we had to tell together. So let's start at the beginning. We start with the premise that, Malaysian women do not have the equal right to confer citizenship to their children on an equal basis as men. Now, for Family Frontiers, that's the organization I'm with, Malaysian women who are married to foreign spouses, and then the child is born overseas, that child is not entitled to Malaysian citizenship because the law presumes that citizenship should only be passed down by the father in this particular instance. Now, these children from this union have to apply for citizenship under what is known as citizenship by registration under Article 15.2 of the Constitution. Now, as with most applications, this is a very arbitrary and opaque process. And the success rate is typically anywhere between 1% and 3%. So it's a very low success rate. So having said that, Malaysia then is one of only 25 countries in the world that does not allow women to pass on citizenship to their children on an equal basis as men, right? So quick timeline of where we come together, of the convergence. So in December 2020, Family Frontiers, where I'm the lead applicant then in the case, along with 6 affected mothers, filed a case in court, at the High Court in Kuala Lumpur. And in this particular case, we essentially asked the government to, the courts to declare that there are 2 inconsistent provisions within the federal constitution itself. So we have a provision that says in 2001, there was an amendment to the federal constitution, which says there's no discrimination on the basis of gender. And yet we have provisions in the federal constitution in relation to citizenship that, as I mentioned before, clearly discriminate on the basis of gender. And so what we wanted the court to do is declare how to read the federal constitution harmoniously. How do you harmonize these 2 provisions to ensure that provisions do not discriminate on the basis of gender? And on that basis, we filed at the High Court, and at the High Court, we won. Of course, the government then appealed the decision, and that meant we had to go to the Court of Appeal. Now, at the Court of Appeal, we lost on a 2-to-1, so the 2-to-1 majority decision. And the judges at the Court of Appeal essentially decided that, yes, we recognize there is a discrimination, but the court is not in a position to rectify this inharmonious reading of the federal constitution. Any rectification of this discrimination needs to happen in Parliament. That is what the majority decision was. And so, of course, we appealed this decision, and we are now on the wait list, or basically waiting for a federal court, a hearing at the federal court, which is the final layer, which is the apex court in Malaysia. However, because this started in December 2020, there were the entire public litigation process was coupled with a lot of advocacy and publicity. And as a result, there was a lot of attention that was drawn to this particular issue. And we managed to build a lot of not just public support, but support from across political lines. So in the lead up, if you recall, in 2022, Malaysia had an election year. And because of the publicity that was generated by the advocacy around this issue, this became a huge election issue. It ended up where we had practically all political parties include in their election manifesto a position on this issue. And it really inclined towards wanting to resolve this discrimination. And so in February 2023, the Pakatan Harapan government came into power post-election, where it was clear that they had made a commitment to resolve this issue. And in February 2023, Cabinet then announced that they were going to amend the federal constitution and essentially give overseas-born children to Malaysian mothers the right to automatic citizenship, which is citizenship by operation of law. And we thought, yes, this is amazing. This is exactly what we wanted. Yay, us, right? That's what we thought. And this was an excellent outcome. However, our happiness wasn't long, because when we asked, of course, once the cabinet had announced this decision, we wanted to have a look at the proposed amendments that the government was going to pull together. And in light of this, and after public pressure to see what the proposed amendments were, in June 2023, the Home Affairs Ministry essentially called CSOs, working civil society organizations, working on issues around citizenship together for a briefing. And that was where we discovered that it wasn't just the amendment for overseas born children born to Malaysian mothers. I'm going to, in short, reference it as the Mothers Amendment. So it wasn't just about the Mothers Amendment. There were, in fact, 8 amendments, 3 new provisions, and 4 repeals, which in and of itself wasn't an issue. However, 5 of these amendments were absolutely regressive and had the potential to worsen statelessness in Malaysia. At this point, I'm going to pass it over to Maalini to continue explaining the 5 regressive amendments.
Thank you, Suri, and it's a pleasure to be amongst everyone here. I think I'll start off with the call that I received early June. It started off with a daunting call asking if I could have a look at the amendments. And at that point, I think DHRRA was honestly looking at the opportunity, the success that Family Frontiers had with the Mothers Amendment, and also looking at possibly advocating for children born out of wedlock to Malaysian fathers. In the whole world, there's only 2 countries that deny fathers to pass on citizenship for children born out of wedlock. And we actually had a couple of very positive discussions with the Ministry of Home Affairs right before June. It took place in May. And when this call came in and said, look, there are other amendments taking place, I honestly thought that, gosh, this government came in and they're actually going to change everything for good, like at once. And I was so excited. I remember I was so excited until I had a look at it and I was like, what is this? This is exactly possibly shutting down lawyers, activists, and civil society organizations that ever worked on statelessness. And right before I get into the regressive amendments, it's important to note that the government did have engagements with MPs right before speaking to us as well, sometime back last year, June 2023. And when the government officials presented these amendments, they emphasized an urgent need to secure the borders and prevent migrants and refugees from gaining citizenship in Malaysia. That's the narrative. And as a result, despite several briefings conducted by the Home Ministry for members of Parliament, no one recognized the impact this amendment brought on statelessness as effectively as activists and civil society organizations did. And as Suri shared, I remember exactly right after that meeting, we were like, wait, that's regressive, that's bad. They're literally taking away rights, right? So the first amendment is to do with foundlings, and what it seeks to do is that foundling and abandoned children will no longer be entitled to automatic citizenship. So the Federal Constitution currently protects foundlings. Section 19B is an evidentiary provision that gives a foundling the benefit of doubt when the date and place of the child's birth and the status of the child's parents are unknown and cannot be proven. The amendment will subject foundlings to discretionary citizenship and the unreasonable place and would unreasonably place the burden of protection of the child as its parentage on the child. And moreover, the process of registration is ridden with delays and there is no guarantee of approval. And there's no answers to why this is being done, except for, back in 2019, there was a federal court decision on foundlings, which the Chief Justice basically directs the National Registration Department to implement the foundling provision. And therefore, our thoughts around this is that this is a reaction that the government is having from the federal court decision. So it's basically trying to tighten up the laws so that it does not need to be accountable to the court. And sorry, I actually jumped into the Second Amendment, but the First Amendment, going back to Section 1A, it's known as Constitutional Safeguard for Statelessness. And this Constitutional Safeguard on Statelessness is a catch-all provision. Basically, it has no age limits. It can be very well used for the elderly population, ethnic groups, children who are abandoned and not necessarily foundling, and other categories of statelessness in Malaysia. And similarly, this provision was being, in combination with another provision, would result in sort of a deletion. Basically, it goes from automatic right to citizenship by registration as well, and it will be ineffective. It will be ineffective to protect stateless person. Now, the third category is children born to individuals who are permanently residing and no longer entitled to automatic citizenship. So this is basically for individuals who have permanent residence, and currently the Federal Constitution states that children born to these permanent residents are entitled to automatic citizenship. However, with the amendment, these children would have to apply for citizenship by registration, a discretionary provision. However, the concern that we have around this is that as DHRRA has been working on the minority pre-independence Indian population of the pre-independence context, a lot of them held Grade IC, a permanent residence card without a citizenship of nowhere. And this permanent residence card were issued in such a way that they were identifiable, whether it was issued to a stateless person or it was issued to a foreigner. And our concern has been that what would happen to a stateless permanent resident and the children that would be born to them. And that's exactly why this was a concern for us. And the fourth amendment was to do with the age reduction of age limit. So there is a couple of provisions that's involved here. 15.2 is to do with the Mother's Amendment, where currently the registration provision is applied. And 15.8 is where all the categories of stateless, or rather childhood statelessness, can apply for citizenship by registration. So as you may have noticed, we do have a constitutional protection for a stateless person. However, that's not implemented and it is usually accessed through courts. That's being taken away. And you also have foundlings who are entitled to automatic citizenship, and that too is being taken away. These two important provisions that allows the right to citizenship as provided in the Federal Constitution being taken away. And then they have a provision here, 15A, that is being used to process all childhood categories of statelessness. And unfortunately, as Suri pointed out with 15.2, the low processing, success rate, it's quite similar with 15A as well. Sometimes the whole family, there is 4 siblings who are stateless, only 1 or 2 gets an approval, and the remaining don't get, even though it's the same set of documents. And also we note that there is just going to be so many scenarios where most often Malaysian parents, when they have a stateless child, they are not aware the child is stateless, and they do not just from day one being born, apply citizenship for them. They actually sometimes only realize it when the child has 13 years old. And so the age reduction from 21 to 18 is going to tremendously affect many of the applications who were not in time. And now the last provision was to do with foreign wives to lose Malaysian citizenship if the marriage dissolves 2 years after receiving Malaysian citizenship, originally date of marriage. So currently this provision is there in the Federal Constitution. However, it states that a foreign wife can lose her Malaysian citizenship if the marriage dissolves 2 years from the date of marriage. And the amendment seeks to replace date of marriage to date of receiving citizenship. And Suri will go into details into this later, but the concern remains why are we doing this amendment, and who exactly they wish to exclude or take away citizenship from. And now what's really important through this is that the proposed regressive amendments primarily amend provisions from citizenship by operation of law to citizenship by registration for foundlings, children of permanent resident, and stateless individuals, including those of Bumiputra or indigenous origins in Malaysia. There is a risk that the proposed amendment will be used to strip away the jurisdiction of the courts in affirming the citizenship rights of vulnerable stateless children, particularly children who have satisfied the requirement to qualify for automatic citizenship under the Constitution. And those regressive amendments remove the government's duty of care and due diligence to protect children and instead place their fate at the arbitrary discretion of civil servants who are not directly accountable to Parliament. And in the absence of constitutional protection specifically designed to safeguard individuals against arbitrary application of government discretion, there is a potential for abuse or misuse of power, for example, through ad hoc introduction of new or additional SOPs, which may not be made publicly known and applied equally. And this is something that we have continued to witness through any application that's placed under citizenship by registration provision, which is discretionary. And and I wish to emphasize that the way the government had provided the narrative that changes of citizenship by operation of law to citizenship by registration is necessary so that we can ensure SOPs are placed and tightened up so that not just anyone able to access it, right? So that's the narrative that the government had placed. Next slide. And so I would like to just give you a little bit more background in terms of the categories of statelessness currently are in Malaysia. We have the first category, most famously known as the pre-independence population, who generally have a red identity card or known as the permanent resident card. They do not hold any other nationality, and sometimes their cards are able to differentiate their status as a stateless person. Category number 2 is children born out of legal wedlock to Malaysian father, and this is the largest contributor towards childhood statelessness in the whole of Malaysia. And the part 2 of this is children born to Malaysian women overseas, the area that Family Frontiers is currently working on. And we have the third category, which is the abandoned foundling. And as I have showed you earlier, the Federal Constitution actually provides for automatic citizenship, but that was never implemented. And so we do have this group that is floating, and oftentimes they were given a temporary residence card. And the fourth category we have is the stateless adopted children. The government does not provide citizenship just because you're adopted by a Malaysian parent, and they have to go through Article 15A, which is a discretionary provision. And currently, this Home Minister has been quite lenient towards adopted children in the approval of these cases. However, our concern is that no children should be differentiated by the state of their birth or if they had an opportunity to be adopted. And children born out of wedlock remains an area not preferable for approval at this point. And the fifth category is definitely the mobile and semi-nomadic Sama Bajau communities who are residing in Sabah. And the indigenous Orang Asli and Asal and multi-generational migrants who continue to work in the plantations all through Borneo and West Malaysia is at risk of statelessness. So this is basically the background of, the type of statelessness that we have throughout Malaysia. Now, speaking of the data is extremely important to sort of even state their existence of stateless, because honestly, the government have done so much of flip-flops whether statelessness exists in the country, and Suri will be covering that a bit more later. And so as I speak now, DHRRA has done data collection in West Malaysia, and it's very limited. We started off with a pre-independence context, and while we were doing the data collection, we were able to also collect on childhood statelessness on the states that we had worked on. And currently, childhood statelessness actually is the largest proportion of data in our system. Almost 9,000 over cases are childhood statelessness, which includes children born out of wedlock to Malaysian parent, adopted children, foundling and abandoned, a combination of this. And I must also say that the stigmatization against children born out of wedlock is so much that even a Malaysian woman abandons her child in a babysitter's home, and this child cannot access citizenship despite having proofs that this child is born to a Malaysian parent, just because the mother is not willing to come forward and say that's her child. And this is also another contributor towards risk of statelessness in West Malaysia, East Malaysia, everywhere. And speaking of East Malaysia, there's really no numbers that's been accounted for. 1/3 of the population is known in Sabah as to be possibly undocumented or consisting of foreigners. However, we do not know the exact proportion of who is stateless in East Malaysia and Sabah particularly. And therefore, it remains a concern that without a categorization and data collection adequately done, we cannot address the problem in Sabah. All right, over to you, Suri.
Sorry, it took a while to find the unmute button while sharing screen. So essentially, once we found that out, once the ministry had presented its proposed amendments to us, we came together and decided, well, because essentially what the government was doing was saying, here, we'll give you the mother's amendment, but we'll take away five provisions that currently ensure pathways to citizenship for vulnerable groups of children. So we'll give you the mothers, but we'll take away these. And that was unpalatable to us because these two issues could be dealt with separately. There was no reason to make it a trade-off in terms of rights. Essentially what the government was doing and continues to do is to barter rights. And we were unwilling to compromise on this. And so what we did was that marked the beginning of stateless groups and Family Frontiers coming together to work on this issue collectively. Because at least for Family Frontiers, the position was that we did not want to trigger or be the cause to trigger the loss of citizenship for other groups of vulnerable children. That was not why we wanted to do this. This is not why we pushed for the rights of overseas-born children, right? This is not why we intended to, and we did not want it to result in the withdrawal of vested rights in the federal constitution for other vulnerable groups. And so what we did was we began lobbying. We pulled together, we did a lot of advocacy and did a lot of lobbying. And what you see on the screen is really an example of like what many of the lobbying moments that we did with different members of parliament, different stakeholders. This included opposition MPs, former prime ministers, and many other different categories of stakeholders, including maybe off-right groups that were initially more prone to support the government with regards to restrictive citizenship provisions.
So just to add to the slide, what was really interesting for us is at the beginning, obviously you're working with a ruling government, and we were being told certain narratives, and that certain narratives included that Sabah wants this amendment. Sabah state government wants this. The opposition has already agreed to these amendments, and we're not sure why you're making a fuss over this, right? So it was really the beginning of us coming together and realizing we have to speak to everyone, and we need to know to what extent and what exactly they understand about the repercussion of these amendments, and if they're willing to trade rights of Malaysian citizens for their children. That includes children born out of wedlock, adopted children, or even founding children that they would adopt. Well, I think this came as a shock to us. We were quite overwhelmed with the whole advocacy plan, and we did not know if it was working. We kept being told that go and speak to the states, go and speak to the royal families, different things. Basically they were diverting us from our course of public advocacy. And then on 22nd March, it was a Friday. I remember that, we went to meet the Minister of Communications, and we were told that we're going to meet you, but hold on, there is a press conference. And I remember me and Suri were sitting out there trying to connect to the internet and know what exactly would be announced. And 2 of the 5 regressive amendments were dropped. And when the 2 of that 5 regressive amendments were dropped, to be honest, we were not even clear which of the regressive amendments were dropped, because there was no clarity in the press conference even, because there was a bit of mix-up in the articles, the way the minister had pronounced or even used the alphabets, right? And so we were really unsure even at that point. But sooner, I think within a day, there was more confirmation coming in that the constitutional safeguard for foundling as well as against statelessness were being dropped. Therefore, it would not be amended. Now, mind you, up till 22nd March, we had no access to the actual wording of the bill. We're actually basically working based on indication that these provisions will be amended. We had no access to the bill wording. And only on 25th March 2024, a Monday, 9 a.m., we get the actual wording. And within half a day, we had to analyze the wording, the impact, and what it means basically for all the regressive amendments that we're looking at, all the other provisions, what exactly it would mean. So on 25th March, first reading was done, and then, as I told you, the actual wording came to our attention. And I think it was a shocker for the family frontiers as well, and the mothers were involved in it, to know that individuals who fought for it would not benefit from the law changes, as it would not be retroactively applied. And on 27 March, we were all sitting in the parliament, waiting for it to be debated. Unfortunately, it was not debated at 5 p.m. It was also the last day of the parliament. It was deferred for the next parliament session. So that situation stands for now, and it's just an overall status. 5 of the regressive amendment, founding has been dropped, children born to permanent residents, current remains, and stateless children protection, constitutional protection for them has been dropped. And the 4th one is the revocation of citizenship of foreign female spouses remains. And the 5th is the age reduction provision for stateless children. Now, as I So as I speak of this overall presentation, I want to let you know that right after the last day of the parliament session, now the opposition party comes in and makes an announcement, a press statement, that they are not happy that the founding provision has been dropped, that it should be back on the papers. Yeah. So that came as a shocker for us as well, and it continues to be a risk for us that these 2 amendments are back on it, because according to the the opposition party, that is that when the narrative was given to us, it was so and so, therefore to ensure national security, therefore the founding provision needs to be back in place. Next slide. So I'm just going to give you a quick reminder again, what is there on statelessness and what is regressive. As I mentioned, Section 1A is to do with children born to individuals permanently residing in Malaysia. And this amendment will affect Malaysians who are born in Malaysia but issued only grade IC, either because they were born out of wedlock or adopted at birth and of unknown parentage, such as founding. And how this is done is actually inconsistent. So if you do not qualify for citizenship when you're through 15A provision after you're 21 years old, at the age of 24, if you're lucky enough, government decides to give you a permanent residence card. And because of this inconsistency, we do not have the numbers who would actually be affected of this provision, especially those who are permanent residents and stateless. And this may very well include Orang Asli and Orang Asal and their children. Next. With the age reduction from 21 to 18, as I had mentioned earlier, stateless child applicants will have shortened time frame to apply for citizenship. And whilst the current government has prided itself for approving citizenship application quite swiftly, we have been traumatized for years and years, where applications can take 7 years, 10 years with no answers for single application. And you know, it's basically and over this time period, DHRRA itself has sort of observed the different SOPs that has been introduced time to time. I mean, prior to this, you know, a stateless person cannot register their marriage just because they have a birth certificate. And now suddenly some of the categories can. And this change of SOPs has caused large number of statelessness remains unaddressed. Next. Now over to you, Suri.
All right, so I will continue here. This is 26.2, and as Maalini gave you a little bit of an overview earlier, the intent of this provision, as it currently stands in the federal constitution, is to prevent marriages of convenience. Now, currently, it states that if a marriage between a Malaysian man and a foreign wife dissolves within 2 years after the date of their marriage, and within those 2 years she has obtained Malaysian citizenship, the government may deprive the wife, the foreign wife, of her Malaysian citizenship. Now, according to the Home Affairs Ministry, it is unable to implement the provision as is because current procedures ensure that a foreign wife cannot apply for citizenship within a 2-year time frame. It takes at least 8 to 12 years. And as such, the government, in order to be able to apply this provision, is proposing to replace the words date of marriage with the words date of acquiring or obtaining citizenship. This means that after an 8 to 12-year marriage, once a foreign wife has received her Malaysian citizenship and by implication given up her original citizenship, meaning she has only Malaysian citizenship, she will then have to remain in the marriage for another 2 years. If it dissolves for any other reason than her husband's death, she will be deprived of Malaysian citizenship. Now, because Malaysia does not, as a result, the concern we have is that this will render a foreign wife vulnerable. They might end up trapped in a violent marriage because leaving her marriage is not an option, or if she does end up stripped of her Malaysian citizenship, this will forcibly separate her from her children and other Malaysian family members. So, the amendment on overseas born children, this is what we term the progressive amendment. It is the only thing that was good about this particular amendment bill. However, the problem we have now is that the amendment is not retroactively applicable. This means that the amendment will only apply to children born after the amendment goes into effect, and that leaves this chunk of children who are currently alive in limbo, right? In a legal limbo. Some may or may not have citizenship from other countries. There are also adult children who are above 21 who may have put in citizenship applications, but those citizenship applications were rejected. Now, our position then is decouple the amendments, proceed with the Mother's Amendment, drop the regressive amendments. However, the Mother's Amendment must be made retroactively applicable. So these are, I won't linger too long because I'm conscious of time. Essentially, we are concerned that the government is refusing to recognize stateless person. This means there is a denial of human rights and access to basic services such as education, healthcare, and dignity. But there is also the problem, what is really worrying to us is also the lack of transparency in lawmaking, because the way these laws were rolled out and they're trying to push these laws through is extremely disconcerting, and they're not evidence-based. Because when we ask the government to justify why it is pushing these amendments through, in their own words, they have told us that they do not have the data. So this is extremely concerning for us, especially because it will exacerbate statelessness, but also even more, and this is even more worrying in light of the fact that the government has no plan to deal with statelessness. In fact, it doesn't even acknowledge that stateless persons exist in Malaysia. So where are we now? MCRA, the Malaysian Citizenship Rights Alliance, is really at the point where we're pulling together some counter proposals. We're also in the gathering a lot of data from Peninsular Malaysia, Sabah, and Sarawak. in preparing our counter proposals, we are consulting with key experts in multidisciplinary fields to respond to the government in terms of the justifications that they put up in terms of national security, in terms of the xenophobic narrative that they've put forward, that migrants, for example, are taking advantage of to access citizenship. So in our advocacy, really, we are focused on protecting and safeguarding stateless persons and those who are at high risk of statelessness, who are born to or cared for by Malaysian parents and have strong links to Malaysia. And this is really to ensure that the public understands that this is about the children of Malaysian citizens and not about migrants or refugees accessing Malaysian citizenship. Right? So, drawing everything to a close, here's some additional resources on statelessness. If you are keen, please scan the QR code. We can also share the slides with you later. And this is how you can help us. You can follow us and correct the narrative to safeguard the rights of stateless Malaysian persons. If you do, and you're Malaysian, and even if you're not, tag the relevant MPs and decision makers, including our Prime Minister, Anwar Ibrahim. Both our social media channels both our organization's social media channels have a lot of information and up-to-date and case studies and stories on this particular issue. And with that, I will stop there.
Amazing. Thank you so much. It's inspiring to hear about how you've sort of been operating on so many fronts to correct the narrative, to put out an evidence-based narrative as well. We really are at time. I know that we have one more hand up. It's John's. And I think his question was about what we in Australia can do to support. But I suppose the question can be broadened out even further to, what can the international community, if anything, do to support these efforts? I won't ask you to respond to that right now because we are out of time. But perhaps if you would put something in the chat, we can take that away to think about in our own respective fields in terms of how we can contribute. I know, Suri, at the end of your presentation, you had indicated some tagging that could be done. I think it was mostly directed towards actors in Malaysia, but if you think that there are equivalents that we can do from outside, then please do include that. With that, I think we will need to conclude this seminar. But before I do, I'd just like to offer huge thanks to Maalini and Suri for pulling together a fantastic presentation and giving us such a comprehensive overview and bringing us all up to speed on a matter that is still very much alive and ongoing. We may have to invite you back to update us again in the not too distant future, and really hoping that all your fantastic efforts are going to pay off in a really positive way. So thank you so much for your time today. I'd also like to thank everybody who's taken the time to join this seminar. It's wonderful to see such a big audience, and just wanted to let you know that if you enjoyed this seminar, our next Asia in Focus seminar is already planned and in the making for early August, a date to be confirmed. It will actually be a conversation with the editors of the forthcoming special issue of the Journal of Ethnic and Migration Studies, Dr. Mohsin Alam Bhatt and Dr. Rudabeh Shahid. The topic will be the special issue on the mutual attrition of citizenship, democracy and the rule of law in South and Southeast Asia. And it will serve both as a launch event as well as a forum for discussion on issues and on the topic of citizenship in South and Southeast Asia. And as I said, that will be in early August, and we will be advertising it once the date is confirmed. And finally, just a quick plug. Some of you, or hopefully a number of you, have already joined our recently activated Statelessness Asia Pacific Research Network, the SAP Research Network. It's a new initiative bringing together researchers and academics working on statelessness issues in the Asia Pacific region. If you think this sounds like you and you'd like to be part of another stimulating group of discussion and conversation around different topics around researching statelessness, then please do join. You can do so by contacting the centre, just the central email, law-statelessness@unimelb.edu.au, and we'll very gladly add you to our mailing list. Our next meeting will be on the 24th of July. And with that, I'd like to thank everyone again and wishing you all a wonderful rest of day. Thank you.